Former CBC Radio host Jian Ghomeshi learns his fate any moment now in a Toronto courtroom. The ruling comes more than a month after his trial ended. 3 women have accused him of sexual assault. Justice William Horkins has been weighing their allegations against doubts raised by the defense. With more on what Justice Horkins has to consider in today's ruling, I'm joined now by criminal defense lawyer Russell Silverstein. You've been with us through so much of this trial. Appreciate you coming in today.
Pleasure. Good morning.
We gather that Justice Horkins is reading his decision right now. He says it'll take a little more than an hour. If you could start by walking us through exactly what he will be ruling on today.
Well, first of all, there are 3 complainants in this case, and each set of allegations pertaining to each complainant has to be ruled on separately. The Crown never asked for an order that would have allowed the judge to use the evidence of one to support the evidence of the other. So this is as if there were 3 separate trials going on simultaneously. So I expect Justice Horkins to review the evidence of each complainant separately and come to a conclusion at the end of each analysis as to whether the Crown has satisfied him beyond a reasonable doubt that these offenses occurred.
Now, why would he have decided to treat each of these separately? Because I know during at the beginning of this trial, there was some thought that perhaps they would be lumped together. And perhaps you can remind us of what that would have meant, what that may have changed.
Sure. I think the idea was to have these charges heard together because the Crown thought he would be bringing an application to the judge for what's called a similar act ruling. And if he could have convinced the judge that these allegations were similar to each other, sufficiently similar to each other, and independent of each other, then he could have convinced the judge to use the evidence of one complainant as support for the credibility of the other. And that would have been a significant benefit to the Crown. In this case, however, I think the Crown could have satisfied the judge that the allegations were sufficiently similar, but there was so much collusion and cross-pollination as between and among the complainants. They had access to each other's stories. They had discussed with each other their allegations. They had meetings where they determined how they would behave and that sort of thing. And that undermined the Crown's proposed application. So what we end up with is really functionally 3 separate trials heard by the same judge in the same courtroom at the same time. But make no mistake about it, Justice Horkins has to examine the evidence of, take Ms. Descouture, for example, and analyze its strength without reference to the testimony of the other complainants.
And we should remind people there is actually another trial that is set for June. Another allegation of sexual assault during a alleged workplace incident when Jian Ghomeshi was working at the CBC. Why would that have been set so far apart from these other 3? And I also want your thoughts on, depending what happens today, whether or not anything may change with that one.
Well, first of all, the circumstances of the other allegation is so different from the circumstances of these 3, it makes sense to hear them separately because there's no way that they could ever be considered as supportive of each other. So that was going to be a separate trial in any event. And I think they were organized in this way for purposes of judicial economy, have the 3 heard at the same time, giving the Crown what they thought was a good faith shot at a similar act ruling. But the other one is so separate that it's going to be heard separately. And I don't know if this decision has been made definitively, but probably by a different judge.
If Jian Ghomeshi, as many people in the legal world expect might happen, if he is acquitted on all charges today, would the Crown have second thoughts about how to proceed or proceed at all with the June case?
Absolutely. The outcome of this case is going to have an impact on the Crown's decision whether to proceed or not. And indeed, the way this trial unfolded is going to have an impact on the Crown and the police and their approach to the next prosecution. I'm sure the Crown and the police learned a lesson over the course of this trial as to the pitfalls of incomplete preparation of witnesses, and they have to guard against the very same thing happening to the complainant in the next trial as happened to the complainants in this trial. Now, if Mr. Ghomeshi is found not guilty, the Crown has to do a re-examination of the public interest in proceeding. I don't know too much about the allegations. I don't know how serious they are. I don't know how strong they are. I don't know what decision the Crown will ultimately make if Mr. Ghomeshi is found not guilty, but they're certainly going to ask themselves the question as to whether it's in the public interest to proceed. And when I say the public interest, that is really what governs the Crown's decision. Now, the public interest takes into account the interest of the complainant. There's no doubt about that. But the Crown's obligation is to take into account a much broader perspective on whether they should be proceeding with that next case.
You mentioned preparation of witnesses, and just a final thought from you, and then I know we'll be chatting with you extensively, especially after the ruling comes out next hour expected. But a final thought from you on how the lawyers did in this case, in your opinion.
Well, let's start with the Crown. The Crown's got much less latitude in the presentation of the case. The decisions he has to make is which witnesses to call. He chose to call the complainants in this case, and I think there was one other witness who did testify, as I recall. But when he gets the brief, the witnesses have already been spoken to by the police, statements have been taken, the police investigation has gathered peripheral evidence, and the Crown has to determine what evidence to put forward. But when it comes to questioning the witnesses, there's not much more the Crown can do other than put the witness in front of the court and essentially ask the witness to recount what happened. I mean, I think he did a fine job in that regard. When it comes to the conduct of the defense, of course, the defense has much more latitude. The defense can cross-examine the witnesses, and the defense did a wonderful job, and all within the boundaries of what is in appropriate good taste. This was a criminal trial like most others that we have in our courts every day across Canada. Witnesses' credibility and reliability is tested on the basis of what they've said in the past, how they behaved, how they explain how they behaved, with being on the lookout for gross inconsistencies that undermine the credibility of the witnesses. Mm-hmm. And when it came to final submissions, I listened to both sets of final submissions, and they both did a wonderful job, given what they had to play with. The Crown, by the end of the case, when he tried to convince the judge to convict, he didn't have a lot of. He wasn't holding a very good hand, I dare say.